Ready, start. Struggle for sensitivity towards offenses against women, children, and other marginalized groups passes through various phases of evolution. Whereas the end goal is most desirable, the journey is not always a pleasant one. At times, the victims find themselves pitched against a system full of insensitive stakeholders, and at other times, the victims find themselves in conflict with the procedural intricacies of the laws in place. Despite the importance of procedural sanctity, it is always a matter of utter failure for the system as a whole when a culprit, that too of a heinous sexual offense, manages to walk free by entangling the victim in misapplication of procedural rules without the knowledge of the victim and without any control of the victim. The present case presents one such illustration from a place called Piro, district Bhojpur, Bihar. In 2016, a few months after the festival of Holi, the victim, the appellant's daughter, started feeling unwell. Upon finding that her health was constantly deteriorating, the appellant's wife took their daughter to her native place in Balia, Uttar Pradesh, for treatment. There she was taken to Jila Mahila Chikitsalaya on 1/7/2016, and upon examination the victim was found to be 3 months pregnant. Upon questioning, she disclosed that she was raped by the respondents, namely Hare Ram Shah and Manish Tiwari, about 3 4 months ago, sometime after the festival of Holi. On the strength of this disclosure, the appellant lodged a complaint at PS Piro, District Bhojpur, Bihar on 2/7/2016, which culminated into criminal case number 209/2016. Investigation commenced and charge sheet was filed in the concerned court. After trial, learned additional district and sessions judge cum Special Judge Pakso Act Bhojpur at Ara found the respondent numbers 1 and 2 guilty for the commission of offences under sections 376 within bracket 2 of Indian Penal Code 1860 and sections 4 and 6 of Protection of Children from Sexual Offences Act 2012. For the commission of the offence under section 376 IPC, the respondent numbers 1 and 2 were sentenced to undergo rigorous life imprisonment along with a fine of rupees 50,000 each. In default of payment of fine, additional sentence of imprisonment for 1 year was imposed. For the commission of the offence under section 6 of Pakso Act, the respondent numbers 1 and 2 were sentenced to undergo rigorous life imprisonment along with a fine of rupees 25,000 each. In default of payment of fine, additional sentence of imprisonment for 1 year was imposed. For the commission of the offence under section 4 of Pakso Act, the respondent numbers 1 and 2 were sentenced to undergo rigorous imprisonment of 7 years along with a fine of rupees 10,000 each. In default of payment of fine, additional sentence of imprisonment for 3 months was imposed. The sentences were directed to run concurrently. In appeal, the High Court examined the entire evidence on record and came to the conclusion that the prosecution did not succeed in proving case against the respondent numbers 1 and